Our next speaker is Renee Jefferson, who is a law professor and award-winning author. She regularly consults on matters related to lawyer and judicial ethics, diversity in leadership roles, and the First Amendment and lawyer speech. She's the author of 3 case books and more than 200 law review articles, and a highly acclaimed book, Shortlisted: Women in the Shadows of the Supreme Court. Her work has been featured on CNN Opinion, Ms. Magazine, the New York Times, Politico, and the Wall Street Journal, along with the Washington Post and other news outlets. It regularly appears on television and radio. She holds the Doherty Chair in Legal Ethics at the University of Houston Law Center, where she teaches ethics, constitutional law, and a writing seminar on gender, power, law, and leadership. So without ado, we can give a nice welcome to Renee here.
Good afternoon. Thank you so much, Rebecca, for that warm welcome. I really appreciate it. How's the sound? Is it okay? Yeah, okay, good. I'm really thrilled to be with you here today to talk about what's next when we think about the Declaration of Sentiments, how long ago it was declared, and how much work remains. And I would like to suggest to you that part of that answer lies in some of our history that you might not know, history related to the United States Supreme Court. And that's what I'm going to be sharing with you in my talk, Sentiments, Shortlists, and the Pursuit of Women's Rights as Constitutional Rights. Now, I imagine that you all are well familiar with the Declaration of Sentiments. It was read out this morning at the beginning of this event. I teach a seminar at the University of Houston where I'm a law professor, Gender, Power, Law, and Leadership. And we start that seminar every year going back to the Declaration of Sentiments. And that's where I want to begin this afternoon with all of you. Thinking about the moment in time where women came together. This is an illustration of what the room looked like. And it's important, I think, as important, who was in the room and who was not. It was a gathering of almost exclusively white women. We know one African-American, Manfred Douglas, was present. And I would suggest to you that part of that gathering is, of course, what galvanized rights that allowed me to get my education as a lawyer, to be standing here in front of you today, but also part of that history is a legacy of why we have not achieved nearly as much as that gathering of individuals thought they would 175 years ago. Some of the sentiments have been secured at least partially. We have more ability to vote, although of course not universal suffrage in the way they might have contemplated. Women can now obtain an education. We are allowed to pursue careers. We can hold property. And yet there are many sentiments where much work remains in terms of full advantage for employment, in terms of equal salary, the way women are perceived compared to men, the judgments we might hold, stereotyping, implicit bias, and women still today being compelled to submit to laws that while we can vote, we may not have elected the individual who is imposing the law on us. Women may not have been around the table when that law was drafted or adopted. My seminar students have critiqued these sentiments in this way. The Declaration of Sentiments call for reproductive rights is glaring in today's political climate. It's especially interesting to point out it's still ongoing, and also equal access to voting. Sadly, not all of the grievances have been fully resolved. Some of the grievances, being compelled to submit to law and the formation of which she had no voice, still endures. One student said this: reading the Declaration of Sentiments stirred up a mix of emotions within me. It made me angry, frustrated, and sad as I realized the extent of injustice that women faced back then. I felt a strong connection to the courageous women who drafted and signed the Declaration. At the same time, it inspired and motivated me to take action. Seeing it as a catalyst for change, that to me really sums up so much of what I have observed today with all of you. But how do we get from that Declaration of Sentiments so long ago to a world where our Constitution, I would argue our living Constitution, recognizes everyone in the way that the sentiments contemplated. And this is where, as I said in my opening remarks, I think we can get some lessons from an unknown history or a little known history about our US Supreme Court. And it comes from shortlists, women who were considered for the court, but not put on the court before Sandra Day O'Connor became our first female Supreme Court justice in 1981. And we all know her story. She was the first. But how many women do you think were considered by presidents for the Supreme Court before Sandra Day O'Connor in 1981? You want to take a guess? How many women do you think were considered? 1, 5, 0, right? Yeah, that's the story we know, right? 0. Well, I spent a decade researching presidential archives and private papers of, as it turns out, 9 women who were considered for the US Supreme Court. Now, before I tell you about them, let me say a little bit more about why I think the history of Supreme Court shortlists has a lot to say about the future of the Declaration of Sentiments and the work that remains. So first off, from 1848, he's monopolized nearly all of the profitable employment. Well, that's certainly true when it comes to who is the Chief Justice of our Supreme Court. We've never had a woman as our Chief Justice, and less than 5% of our Supreme Court justices have been women. Or take this one. He's created a false public sentiment by giving to the world a different code of morals for men and women. Or he has endeavored in every way that he could to destroy her confidence in her own powers, to lessen her self-respect, and to make her willing to lead a dependent and abject life. Think about the headlines and the way women who actually end up on the Supreme Court, who come off the shortlist, have been portrayed. A single Supreme for Sotomayor, a labor market punishing to mothers. Then comes the marriage question when Kagan was nominated. When Obama had the audacity of hope to nominate not 1, but 2 women to the US Supreme Court in relatively short succession in 2009 and 2010, we saw headlines like these. I can tell you when Justices Alito and Chief Justice Roberts were appointed by Bush not that long before them, no one was focusing on who would escort them to fancy Supreme Court dinners or whether they were parents. They weren't being asked who wore it better at their Senate confirmation hearings, like Kagan and Sotomayor were when they happened to show up in similar blue blazers. And it was this kind of media coverage that led me to conduct an empirical study looking at every article written in the New York Times and the Washington Post from the early 1970s through the confirmation of Justices Kagan and Sotomayor. Now, I'm not here to tell you about the media study. We could spend our whole time focusing on that. I will say, coding for over 100 variables, we were able to show, perhaps not surprisingly, that in fact the media does engage in very gendered coverage of our female nominees to the Supreme Court. And for those of you who are wondering, well, maybe it's gotten better. I mean, that study was from 2009, 2010. It was published in 2012. It didn't get better. It didn't get better when now Justice Barrett was considered for the court. Lots of focus and attention to her family and the headlines. And I want to be clear, though, it isn't just the media that's at fault here. Sometimes the media is simply reporting what's happening. Amy Coney Barrett, during her Senate confirmation hearings, was asked, who does the laundry in your house? By Senator Kennedy, for example. No male justice was ever asked about the domestic responsibilities in his household as part of his confirmation hearings. And of course, it wasn't any better for Justice Ketanji Brown Jackson either. In fact, she was scrutinized for qualifications like her LSAT score, which is the exam score you need to get into law school, in a way that no justice before her ever had, and I would suggest reflects the additional burdens and hurdles that minority women face in moving into professional life, and especially when they are ascending into positions of power. The most interesting article I read in my study, and I looked at thousands of newspaper articles during that time period, again, in the New York Times and the Washington Post, I brought with me to show you. It's from 1971. And I know it's a little bit hard to read, but what you'll see here is the headline is potential high court nominees. Now, this, of course, was when President Nixon faced 2 vacancies on the Supreme Court. So he was looking for 2 individuals to appoint to the court. And this article is significant for a couple of reasons. First, he's the first president to make a shortlist public. Before Nixon, you never heard about the shortlist. You would only hear who the president had selected and was going to be the nominee. It was also significant because there are 6 names, 2 of them are women. So it wasn't 0, there were at least 2, right, in our tally. We can keep track. Sylvia Bacon and Mildred Lilly. Mildred Lilly, among her qualifications, I pulled it out here and I saw a couple of you chuckling, maybe you can actually see it, included that she had no children, fortunately, and in her 50s, her mid-50s, still had maintained her bathing beauty figure. I can tell you that there was nothing about how Herschel Friday filled out his swim trunks or anything like that amongst the men that were on the short list. Now, of course, this article fed exactly into the media study. But again, that's not why it was so interesting to me. I wondered, who's Mildred Lilly and who's Sylvia Bacon? Why haven't I ever heard of them? Why didn't I learn about these women in a high school history class? If they were sufficiently prominent to be on a president's shortlist, why hadn't I at least learned about them in law school? And also, how many other women were shortlisted for the US Supreme Court before Sandra Day O'Connor? I had no idea. And so that's what set me out across the country, literally combing through presidential archives to uncover and answer that question. And it led me to the shortlisted sisters, as I affectionately like to call them, and an untold her story of the Supreme Court. And it's in this story of these women that I would suggest to you we have some meaningful lessons we can draw upon when we think about how we make sure 175 years from now, our daughters aren't reflecting on the fact that we still have this list of sentiments that have gone unfulfilled. So let me tell you a little bit about these women, and then I'll conclude with some of those lessons. Anybody want to take a guess the first president to shortlist a woman? I'll give you a hint. It wasn't Nixon, so you've seen his shortlist. So who do you think was first to put a woman on his shortlist for the Supreme Court? Yeah. Exactly. A, you passed the class. You did very well. It was FDR. And this is a memo from his archives, the Roosevelt archives. The date is 1937. Again, I know it's a little bit hard to see, but up there in the handwriting, it's the Supreme Court appointment file. And amongst his list of potential appointments was a woman named Florence Allen. I have her name underlined in red there, of Ohio. Now, I will say, if you're a history buff, you might note that the year 1937 is significant. That's when FDR was contemplating increasing the number of justices on the Supreme Court because he was really frustrated with the fact that they were striking down his New Deal legislation, a sentiment that I know is in the public space now too, when we think about perhaps that being a remedy for our own Supreme Court. It's not lost on me. FDR had the ability to replace every justice on the Supreme Court during his many years as president. And it's not until he's thinking about adding additional seats that it becomes plausible to put a woman on the court. Let me tell you a little bit more about Florence Allen and how she ends up on this list. So Florence Allen made her career by securing the right of women to vote. There she is with her flag. She traveled all through Ohio to help women secure the right to vote. And once they had it, she turned around and asked for their vote. And they handily put her on the Supreme Court of Ohio. She was the first woman to hold that seat. When she went to law school, she was born 40 years after the Declaration of Sentiments. So about 60 years later, she goes to law school. The only woman at the University of Chicago. She was miserable, so she transferred to Columbia, where there were a handful of women. She, again, secures her seat on the Ohio Supreme Court through the votes of women. And it's from there that FDR plucked her off and appointed her to the Sixth Circuit Federal Court of Appeals. That's where she served the rest of her career. When she arrived at the Sixth Circuit, the newspaper reports of the day said that some of her male colleagues fell ill and had to take to bed over the idea of presiding with a woman. There was not even a restroom for women in the courthouse. They had to secure federal funding in order to build her a bathroom. The entire time she served on that court, She was never allowed to dine with her male colleagues. They would go to an all-men's dining club, and she would, in her chambers, warm up her meal on a hot plate. Pay attention to that hot plate because it's going to become another part of this story. So that's Florence Allen. The next president to consider a woman for the Supreme Court, it's actually JFK and LBJ. They both considered Zoya Menshikov. Zoya Menshikov came to their attention because she had taught at the University of Chicago with an advisor, Nick Katzenbach, who was recommending, he was an assistant attorney general, recommending potential nominees for the court. Zoya had been the first woman to teach at the University of Chicago. Before that, she was the first woman to teach at Harvard Law School. When she moved from Harvard to Chicago, she went with her husband, Carl Llewellyn. She was the professor Chicago wanted, but they were going together as a couple. They were both hired by the University of Chicago, but because of anti-nepotism rules at the time, only one spouse could have full tenure. The other had to be a lecturer. Even though she was the sought-after faculty member, they made Carl the fully tenured professor with a higher salary. It was not until he died that she was allowed to have tenure at Chicago. She would go on to become the first permanent female dean at the University of Miami Law School, and also the first female reporter at the American Law Institute. She has a few other firsts that I'll get to in a moment, but now let me move on to the next. And now here we have, you get to see Sylvia Bacon and Mildred Lilly. You already met them. They were in the New York Times article I showed you from Nixon's shortlist. So Mildred Lilly was a judge from California, in addition to her other attributes reported on by the New York Times. Sylvia Bacon, a judge from Washington, D.C. And what I will tell you about the two of them, it's a little bit more actually about Nixon. I said he was unusual in that he made his shortlist public. I listened to the Oval Office tapes. He had no intention of putting a woman on the court. In fact, he said things like he thought women should not even be allowed to vote. So why would he put women on his shortlist? He wanted their votes. He was up for re-election. And he was hearing the rising women's movement in the early 1970s, the call for the ERA. He was terrible on women's rights. And so he quite literally put women on the short list to be able to say, we considered you, and maybe next time it'll be you. And he gave a speech like that after he did not choose Lilly or Bacon, but instead put Lewis Powell and William Rehnquist, who would go on to become Chief Justice, onto the court instead of the two of them. Next, we have President Ford. He also considered two women, shortlisted two women, Cornelia Kennedy and Carla Hills. Carla Hills was his Secretary of Housing and Urban Development. She was the first woman to hold that role and had very young children at the time. When he reached out to her, when he had a vacancy, to see if she wanted to be considered, she did what I call self-shortlisted. She said no, she took herself out of the running. We don't know exactly why, but perhaps it's the media scrutiny, perhaps it's not wanting to be the first, which is a theme that I explore more in my book, and we can talk more about when we talk about strategies. But let me also say a few things about Cornelia Kennedy. Cornelia Kennedy was a judge from Michigan. Like Florence Allen, she started her career by going out and asking women to vote for her, and they did. She started as a state elected judge in Michigan and eventually was appointed to the Federal District Court and the Sixth Circuit Court of Appeals when Florence Allen retired. It was like Florence Allen had the woman's seat, I guess. When Florence Allen left the bench, Cornelia Kennedy took her spot, but she wasn't having it, this idea that she would be excluded from lunch with her male colleagues. And she went to them and said, you have to go somewhere else. I need to be a part of this. We know what happens around the table at lunchtime, the professional networking, that's where the power moves are made, right? And she knew this too. The all-male dining club quickly changed their policies, allowing women in. But Florence Allen still gave her that hot plate, and Cornelia Kennedy kept it on a marble pedestal in her chambers until she passed away. And it now, to this day, is held by women judges who sit on the Sixth Circuit. They keep it to remind themselves of the literal physical barriers to women's presence in the courthouse. And it very much, in my mind, is symbolic of barriers that might be harder to see, but still endure today. Now, for those of you who are wondering, like, how many more presidents do we have to go through? We are now at Reagan and his shortlist. Okay, so Reagan, of course, gives us Sandra Day O'Connor, but what you might not realize is that he had a number of women on his shortlist that he was considering, which makes sense because he campaigned on a promise to give us our first female Supreme Court justice, and he delivered. Although his campaign pledge was, in my mind, a bit like Nixon's playbook, and here's why. Reagan was terrible as a governor in terms of putting women on the courts. He had a horrible record. He also opposed the ERA. He had to do something to counteract running against Carter, who was much better for women. And so he campaigned on the promise to put a woman on the court. In addition to O'Connor, he considered Cornelia Kennedy, who you just met. She'd been considered by Ford. And there's an amazing handwritten letter from Ford to Reagan in Reagan's archives, where Ford is saying, I should have put her on, will you do it? Like kind of punching, like now's the time. In addition to Cornelia Kennedy and Sandra Day O'Connor, Reagan considered Joan Dempsey Klein, who was a judge from California, a huge proponent of equal rights for women, and also the founder of the California Women Lawyers Association and the National Association for Women Judges, a huge activist. Reagan considered Susie Sharp, who in many ways was the opposite of Judge Klein. Susie Sharp was the first female judge on the North Carolina Supreme Court and the first elected Chief Justice of any state court, again, North Carolina. But she was not a feminist in any way. She opposed the Equal Rights Amendment to the point that some suggested she was behaving inappropriately as a judge to come out with a stance like that. She would regularly tell women, you can have a professional life or you can raise children, you can't do both. You might be wondering, like, why would I want to include her in this cohort? Well, but she reflects a view at the time and one that endures even yet today. What she did do, however, as a judge, I will say I admired, because she would set her personal beliefs aside to rule as the law compelled her. She was an avowed racist, but also wrote the opinion desegregating the first private golf course in North Carolina. And then we have Amalia Kearse. Amalia Kearse is still alive today. She sits on the Second Circuit Court of Appeals. She is a senior judge in that role. And she was not only shortlisted by Reagan, but she would go on to have her name floated when Clarence Thomas's nomination seemed like it would not go through. And she was shortlisted again by President Clinton when he appointed Justice Breyer. Of course, when Breyer retired, his seat went to Ketanji Brown Jackson. So finally, an African-American woman holds that seat. It was not Amalia Kearse, although I do think that it's quite significant. She was shortlisted by presidents for both parties. And that tells you, and it certainly undermines any notion that African-American women have not been qualified for the Supreme Court for decades, as long as white women were and long before. So those are the shortlisted sisters. Turns out we could have a court of all women if they had made it off the shortlist. They didn't. They should have. What lessons do their lives offer that can help us think about how we now in this moment advance the declaration of sentiments and the goals that remain unrealized? Let me offer just a few strategies that go to transcending shortlists, but I also think go to helping us enact sentiments. I want to start by first just pausing for a moment to share with you something I discovered in my research, and it's how I define what it means to be shortlisted now. Now, to be clear, to be selected, you got to be on the shortlist. But I, in my research, saw time and time again how being shortlisted meant this: qualified for a position, but not selected from a list that creates the appearance of diversity, but preserves the status quo. You can probably think about examples of this from your own professional life. It certainly extends well beyond the Supreme Court. Nixon was the most glaring example of this, right? And I can imagine that there are many other examples. If we had time, you would be able to share that you have seen. So how do we move beyond this dynamic? It's a critique that we can make of a selection process, but it's a critique that we can make and identify anytime someone is pledging a commitment to diversity, but implementing a tool that actually perpetuates the status quo. How do we move forward? In my shortlisted book, I conclude with 8 strategies. We don't have time to go through all of them today. I'm going to focus on just one, but I want to just mention briefly those 8 because I think that they're worth at least having them in the back of your mind. The first is leveraging legal education. Every single one of these women wanted a career in a world where women were largely excluded from any professional life unless they wanted to go on to teaching. And the way they obtained a professional life was to pursue a law degree that allowed them not only to be fulfilled as professionals, but to break down the legal barriers that held them back. Every single one of these women partnered with people and surrounded themselves with people who valued women's professional lives. They collaborated to compete. When Joan Dempsey Klein wasn't selected from Reagan's shortlist for a seat on the Supreme Court, I imagine she felt a wave of emotions, including disappointment. But she channeled that to collaborate with Senator O'Connor, testified on her behalf at her Senate confirmation hearing, and not only talked about O'Connor's qualifications for the bench, but also talked about what she would face as being the first woman in that role to really educate the court that she would be joining to educate the public. They all created opportunities. They did not wait for a woman's bathroom to be built before they insisted on joining the public space. I'll come back to 5 in a second, and I will just say the last 3. Using caution and self-shortlisting. I mentioned the example of Carla Hills, where she took herself out of the running. Rather than taking oneself out of the running, I recommend requiring, demanding, seeking out what you need in order to step up into that leadership role. All of the women struggled with issues related to childcare, whether they were trying to raise children and battling who would raise them, or they were a Susie Sharp who felt that they couldn't have children because of their professional obligations. And finding mentors in her story. That's what happened for me as I wrote this book. Being in the archives of these women allowed me to know them in intimate, personal ways, more deeply than I even know some of my own living mentors. It's why I think it's so important, and I'm so grateful that all of you are here to learn about their stories. We need more of these untold stories told and told, uncovered and told again. But let me say just a little bit more about the strategy I skipped over. Implementing structural changes without further burdening those who have been excluded from professional life. There's one president's shortlist I didn't mention. Were you wondering why didn't I mention Carter? I mean, he absolutely would have been the president to give us our first woman on the Supreme Court, but he had no vacancy, so he couldn't. But here's what he did do. He gave us Ruth Bader Ginsburg on the DC Circuit Court of Appeals and a number of other women. In fact, he put more women on the federal bench than all presidents combined before him. And he did that by implementing a structural change to how nominees are selected. Rather than behind closed doors, friendships, and that sort of thing, he established commissions throughout the country, 12 of them. Those commissions were diverse in makeup. They included women, men, minorities. They were tasked with vetting applicants for courts, for federal courts that were diverse in makeup. And importantly, this is maybe the most important thing, a qualification for receiving your federal judgeship, you had to demonstrate a commitment to diversity. So not only did he give us the notorious RBG, he also gave us Judge Kearse. I hope it wasn't lost on you. She's the only minority woman who shows up in this study. And without Carter's structural intervention in how individuals are placed on our federal courts, I don't think she would have been there. She sat on one of those commissions and then eventually was selected for the Second Circuit Federal Court of Appeals seat that she still holds today from one of his commissions. One more strategy I'll share. Now, this is a photo of an annual meeting that I go to every year as a law professor. In your professional lives, you may think of annual meetings that you go to. Soya Menchikov, who again was the second woman to be shortlisted by a president, LBJ and JFK both considered her. She was also the first female president of the Association of American Law Schools, where this annual meeting is. Now, why am I showing this to you? Why should you care about this? She noticed that every year, men were coming to the annual meeting of law professors, but female professors were not. And this matters because as a law professor, this is how you can get a job, how you can keep your job, how you might have the opportunity to change careers. That media study I told you about, I won an award for that early in my career. at a time where if it hadn't happened, I don't know if I would be standing here before you today, a fully tenured professor writing a book about this. And if she hadn't made the structural intervention of, you wonder why women weren't showing up? The annual meeting at the time was held from the day after Christmas until New Year's Day. They were all home with childcare responsibilities. In fact, it was apparently a running joke amongst the male faculty members who would attend that they got to get out of the house when it was all chaotic and they could think their big thoughts and do their networking. She changed the meeting time. She changed the meeting time so that when I was raising my toddlers, I could go and talk about my work. And sometimes you don't have to be a president signing an executive order to change the way judges are selected in this country. Sometimes a solution can be as simple as changing the meeting time to make sure that those who had been excluded in the past can show up and be there. There's one more strategy I'll share that doesn't come from my book. It's a strategy that I have thought about, and frankly, this is what happens when you write a book. You're like, oh, as you talk about it, the book was written in 2018, it was published in 2020, and then it has a life of its own. And I'm like, oh man, I missed the most important strategy. I missed the most important strategy, and that's voting. When we think about the gathering of the Declaration of Sentiments at a time where more than half of the country could not vote, and contemplating a world where that vote would empower and enable the goals that were realized from that meeting. We talked a lot about the Equal Rights Amendment today, also unrealized. Florence Allen, she launched her entire legal career and the legal career for many women after her by securing the vote. And we can do that now, voting in terms of who is your representative, but equally important, voting in terms of what are our laws. And even if you are not a legislator, you have the ability to vote, especially at the state level, to change laws. In my home state in Michigan, in our last election, we not only elected our governor, but we also amended our constitution. So there's a constitutional right to abortion in Michigan. The power of voting is, I think of my list of strategies, the most important, and certainly the one most critical to realize the Declaration of Sentiments as it was contemplated here 175 years ago and remains so equally important yet today. I have a little bit of time. If there are questions, I would be happy to answer them. And I believe there's a mic that could be brought to you if anyone wants to raise a question. Oh, we have one.
Following current Supreme Court movement to expand the number of justices today?
Yes, so it's interesting. I have studied judicial ethics for 2 decades, and there's never been more interest than there has been in the last, 12 to 18 months in the ethics of, especially our Supreme Court, although we should be thinking about our judges across all courts. And one proposal for reform has been to expand the number of justices. Other proposals for reform, in fact, the Senate just passed out of the Judiciary Committee this week a bill related to Supreme Court ethics. What I will say, you asked about expanding the number of justices, and would it solve in the short term, depending on who can fill those appointments, the problems we face now? Yes. Might it create additional problems down the road if that power is put in the wrong hands? Yes. I'm going to be very lawyerly and say, though, that we always have to think about it's like walls behind the veil. Would we want that power in the hands of a different administration, right? And so that's what gives me a little bit of pause. But I will also say this. We, the people, have way more ability to shape our Supreme Court than we realize. Congress has the ability to tell the Supreme Court you should hear more cases. This current court is hearing fewer cases than ever. I don't know how deep you want me to get in the weeds on this, but the Supreme Court gets thousands of petitions to hear appeals every year, like more than 7,000. They're down to hearing like 60-ish. Congress could expand the jurisdiction of the Supreme Court to require more cases. When the Supreme Court decides whether or not, they call it grant cert, to hear a case. Right now, and this is something that the court could decide itself. They could decide fewer justices need to weigh in to make that happen. Instead of needing 4 votes, you could need 3. Now, a court where we have 3 justices that we would say are more liberal might be likely to grant review to a lot of different cases that they can't get a 4th vote on. So in addition to changing the number of justices, which could alter the results and outcomes of cases, there are other mechanisms that could be put into place to change the kinds of cases that are heard and the number of cases that are heard. As for whether or not the Supreme Court needs an ethics code, on that I can be less lawyerly. Yes, they do. All of our state judges have a code of ethics they follow. All of our federal judges, except the U.S. Supreme Court, has a code of ethics that they follow. The Supreme Court should seize the opportunity to create their own code of ethics and also, importantly, have an enforcement mechanism in place, because as we know, words on paper are meaningless unless there is also a mechanism in place to enforce them and have them reviewed. That's a great question.
Excuse the possibility why one question.
Oh, no, please.
Is it always Congress that makes all the rules about the groups?
So not always. Congress has the ability to make rules, but also the court can make its own rules too, right? And that gets into a great constitutional 101 question, which is separation of powers. Who has the authority to make rules governing the Supreme Court? And, I think perhaps the biggest leverage Congress has, frankly, is the budget, right? Like Congress could just say, you get $0 this year unless you create an ethics code for yourself. Your question is an important one because we want our Supreme Court and all of our courts to be independent of now I'm going to say independent of the political process, and probably everyone's going to roll their eyes because, of course, the Supreme Court is highly politicized, especially in this current era. But we want our courts to be independent of that. And part of that is why courts largely are self-regulated when it comes to the recusal, whether or not they're going to step away from a case because they have a personal interest in it or a chance that they'll be biased. They have ethics obligations in terms of reporting, financial holdings and that sort of thing. But Congress has the ability to intervene and to impose some rules. For example, members of the federal judiciary, the lower courts, follow similar federal disclosure requirements about their income than our members of Congress do. And they do that because Congress has required it of them. So it is a fine line. And if you're speaking to a member of the judiciary, they would probably land on one side of that line and members of Congress would land on the other in terms of who has the ultimate authority to implement a rule governing our courts. And this is why we have a Supreme Court that has yet to adopt its own ethics code, I think, because who would be answering the question about the validity of an ethics code imposed upon them? They would. It would go to them. Great question.
When you're talking about how many cases they choose to hear,
That's something that Congress, actually has the ability to impact. And the court's jurisdiction could require them to hear certain kinds of cases. So Congress does have the ability, and that's where who your representative is matters, and their view on using the power that Congress potentially has to shape our Supreme Court is important. A story I love to tell, and it, I think, answers your question a little bit, although coming at a slightly different way, is a dissent from Ruth Bader Ginsburg in a case involving a woman named Lilly Ledbetter. Lily Ledbetter had worked at Goodyear Tire her whole career and learned afterwards, and unfortunately too late to find a remedy in a federal statute for the unequal pay. She won a jury award. The US Supreme Court reversed it. And as she does, Ginsburg wrote a fiery dissent. And in her dissent, she reminded all of us that if you don't like what the Supreme Court has done, you don't have to live with it, at least not always. You can go to the legislature. You can go to Congress. And that's exactly what happened. The Lilly Ledbetter Fair Pay Act is a direct result of a Supreme Court decision that did not support women. And it was the first piece of legislation that President Obama signed when he went into office. So Congress has the ability both to impact some of the mechanics of what the Supreme Court does, and Congress also has the ability to remedy the outcome of a Supreme Court decision that has denied rights and entitlements that are deserving to someone who's done without them.
Your next door is the Ledbetter. And then our key parents and the topic to connect with the next door the environment through what has to be through that.
I love that. That's wonderful. That's wonderful. Well, thank you all so much. I really appreciate it. And this is where you can find me if you have more questions. And enjoy your time here. And go see the Lilly Ledbetter Fair Pay.
And you have some available in the bookstore too. So
yes,
grab a copy of it. It's on bookstore. You can check that out at bookstore as well.
Thank you. Thank you. Thank you.